What starts as a simple small claims dispute over furniture quickly turns into a masterclass on how missing court dates can cost you big. This case pits an everyday consumer against a national furniture retailer, and from the very first words, the judge makes it clear the situation has a long, unpleasant history. We're talking default judgments, missed hearings, subpoenas ignored, and a courtroom visibly frustrated by one side's repeated absence. And here's the twist. Even when the judge openly admits the outcome feels unfair, the law still demands enforcement. How does someone end up paying cash and losing the furniture? How does a company rack up what the judge calls $10 zillion of bad publicity over a few missed appearances? And most importantly, should procedural mistakes outweigh what feels like common sense justice? Stay with us, because this case isn't really about furniture at all. It's about accountability, court rules, and the brutal reality that court doesn't wait for anyone who doesn't show up.
Small claims court, but I had a hearing. You have to show a legitimate defense and good cause for not appearing. I didn't find any good cause for not appearing. So the plaintiff then did a subpoena to discover the ability to pay on this debt, and nobody appeared from the furniture for that. So we set a show cause hearing regarding this. So, Mr. Kloppenstein, thank you for being here. Miss Manley, you as well. Mr. Kloppenstein, will you raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
You so far have got about $10 zillion worth of bad publicity out of this case. I found on her behalf by default in the amount of $1,669.17, $62.28 for a total of $1,735.42. She wanted to add some other items, but they weren't part of the original complaint, so I wouldn't allow them to be added. You moved to set it aside. I denied the motion to set it aside.
This is where things quietly but decisively turn against Ashley Furniture. When a party fails to appear for a properly noticed hearing, the court doesn't speculate, it acts. The default judgment isn't a punishment. It's a procedural consequence. The judge explains that nobody appeared on behalf of the company, so judgment was entered for Miss Manley. And once that happens, undoing it isn't easy. To set aside a default, you must show two things: a valid defense and good cause for missing court. Here, the judge explicitly says neither was proven. Even more damaging. This is small claims court, relaxed rules, simpler procedures, and fewer excuses. The court bent as far as it could, but when deadlines pass and no one shows up, the system moves forward. Question for you: should courts be flexible when businesses say they forgot, or does that open the door to endless delays?
She got the furniture returned plus other stuff, but this judgment entered by default. So the ship has sailed. You owe that amount of money. Do you have the ability to pay that?
Your Honor, we did switch out the piece for her.
I got it.
Okay.
I got it.
Okay.
But then the lawsuit was still going. You didn't show up, so a default entered on her behalf. You had a motion to set aside the defense. The default. You may have had a meritorious defense, but you didn't show up for the hearing. And I had a hearing to find out why, and there wasn't good cause other than I guess they forgot. So yes.
Your Honor, I was out of the country and I did not know about it, but we thought it was made whole by exchanging the piece.
I understand.
We thought it was made whole.
It wasn't. And I didn't like entering the default. I thought she got paid twice. I thought she got made whole plus she got $1,600.
Yeah.
But you got notice. There was a hearing. She was here. Nobody showed up, and a default entered. So yes.
When the judge says the ship has sailed, that's not just a metaphor. It's a legal reality. At this point, the judge is no longer interested in hearing defenses about furniture swaps or customer satisfaction. Why? Because those defenses should have been raised before the default judgment. The courtroom dynamic shifts here. The judge acknowledges the situation feels unfair, even stating he didn't like the outcome. But fairness and procedure aren't always aligned. Once a default is entered and upheld, the court's job becomes enforcement, not reevaluation. This moment highlights something many people misunderstand. Courts don't decide cases solely on who's right. They decide them on who shows up, files properly, and follows rules. So ask yourself, is justice about the truth of the dispute, or about respecting the process that resolves it?
Not sure why this is a show cause. Just failed to pay, failed to appear for the motion, but I don't remember a subpoena for discovery. It's an order to show cause why you should not be in contempt, but I don't see that you missed anything to be in contempt.
I'm sorry.
Yes.
I had to pay the St. Joe County of Mishawaka to have Ashley's furniture served.
I'm trying to figure out what date that was. I'm looking and it's not in the paper file in front of me.
And then he didn't show up.
Yes, I'm trying to determine what date that was.
I filed, oh wait, let me make sure.
Here's the subpoena. Subpoena was for him to appear on August 11th.
This section exposes how procedural missteps pile up fast. This subpoena wasn't just a formality, it was Miss Manley's attempt to legally uncover whether the defendant could pay the judgment. When Ashley Furniture didn't appear, the court had to determine whether that failure rose to contempt. Here, the judge does something important. He carefully walks through service records, acknowledges confusion, and ultimately declines to hold contempt. That's judicial restraint in action. But restraint doesn't erase consequences. The plaintiff still spent money, time, and effort chasing compliance. This is a key teaching moment. Even when a court gives you the benefit of the doubt, the financial and reputational costs don't disappear. Viewer question: should companies be held to a higher standard when navigating court orders? Or does equal treatment mean equal accountability?
For St. Joseph County, which would be South Bend. Cost her $88 additional. Well, they served it on Ashley Furniture, Great Road, Mishawaka, Indiana is where they served it, which is St. Joe County. So they served the business, not you. All right, at any rate, the judgment stands, whether it's fair or unfair, it does. So she wants, it was for a discovery hearing, for you to come here, for me to put you under oath so she could ask questions to you about your ability to pay on this debt. Now, you're not an attorney, and I don't hold you to that standard, and neither is she. We're in small claims court, and the rules are more relaxed, but they still are the rules of civil procedure.
This is one of the most uncomfortable truths in the case. The judge openly acknowledges what everyone's thinking. Yes, this looks like a double dip. The plaintiff keeps the furniture and gets the money. And yet, the judge doesn't flinch. Because the law doesn't reward intentions, it enforces consequences. The moment Ashley Furniture failed to appear, testimony went unchallenged. That's what locked this result into place. The judge even says he didn't enjoy issuing the default, but enjoyment has nothing to do with authority. This is a powerful lesson for viewers. Court outcomes don't always feel fair, but they are often predictable when rules are ignored. Would you accept this outcome if you were the defendant, or does procedural accountability justify the result?
That you failed to show up for and raise the defense. So I was compelled to issue a default judgment. So you dropped the ball to the extent that it's cost you $1,735.42. I understand that you have some defenses you wish to raise. And I didn't enjoy entering this default judgment on March 10th, but you didn't show up. And then I had a hearing regarding why you didn't show up, and I didn't find good cause to find out why you didn't show up. So the ship sailed. You owe this money. Do you want to pay it, or do you want to get another $10,000 worth of bad publicity? $1,735.42 plus 88.
Do I not get the furniture back, Your Honor?
No.
So she gets the furniture?
Yes, she gets a double dip. because of your failure to appear for the hearing, which is what stopped. You prevailed. I took testimony. She was unhappy with what she got. She wanted to sue for even more.
Here, the confusion about jurisdiction highlights another misunderstanding many people have about small claims court. The judge makes it clear, jurisdiction can exist in multiple places where the transaction occurred, where the product was delivered, and where the parties operate. And unlike higher courts, attorneys aren't even allowed unless the case is removed. That's intentional. Small claims courts are designed to be accessible, fast, and final. Ironically, that simplicity leaves less room for recovery once mistakes are made. The judge emphasizes that this case dragged on far longer than it ever should have, costing both sides time and stress. Viewer question: does small claims court do a better job at justice because it's simple, or does simplicity make mistakes more expensive?
We specifically had to be here so we could all be in the same place at the same time. But in order for her to do that hearing, she paid an additional $88 to have a South Bend, St. Joe County, Indiana deputy serve you. So that's where we are. It's difficult to execute on an out-of-state judgment. If this were in Michigan, she could seize your assets. She could come with a court order with a deputy and take money out of your till, I suppose. I don't think that's ever been done, but seize tools, trucks, that sort of thing to auction to pay the debt. This has been, you've been here 6 times. I don't know. You've both been here repeatedly. I've spent, I don't know, 20 hours on this case regarding this furniture.
This is the first time I've ever been here physically.
Okay.
I was at, before it was Zoom.
All right. Well, that's why I wanted to get everybody here. So the question is, are you willing to pay $1,824?
Again, Your Honor, she keeps the furniture. I pay her back for the furniture.
Yes.
And she's able to keep it. And
Yes. I don't enjoy it. You didn't show up for the hearing. I took testimony. A default entered. She's still unhappy. She wants more than this. So I can't be
This
any
is
more.
the turning point where pressure meets reality. The judge doesn't threaten, he presents options. Pay the judgment, or risk seizure proceedings and even more public exposure. The phrase bad publicity isn't accidental. It's a warning that court records live forever. Businesses especially feel that sting. At this moment, Ashley Furniture finally concedes, not because the outcome feels right, but because prolonging the fight only makes it worse. This is accountability through exhaustion. The system didn't force compliance with anger. It forced it through inevitability. Question for the audience: should legal disputes be about winning or about knowing when to stop
Not going to
digging?
pay her the money. She can get an order to seize your property and fight it out that way. But
may I ask another question? Your
yes, sir.
And talking to my local attorney, he thought the jurisdiction would be in St. Joe County.
Jurisdictions at both ends.
Where you buy it? Because we have no stores in
Yes,
Yeah.
where she is and where you are. And it's a small claims case. The furniture was delivered to her in St. Joe County, Michigan.
or picked up. I believe it was picked up.
And so,
A repair was
A
sent to
repair.
my house.
But the furniture was initially picked up in St. Joe County and at the store at the St. Joe County. I'm not an attorney. I don't understand.
I
a lot of the
understand,
things, you know.
but yes,
And our representative from Fort Wayne said he could not represent us in Michigan.
well, and you can't have an attorney in small
Yeah,
claims
that's
court.
right. He
You
also
can
said-
remove it to the general division of.
This case is a textbook example of how procedure outweighs perception in court. The judge ruled clearly. The default judgment stands. Payment must be made within 21 days. And the matter ends unpleasant for everyone involved. The broader lesson is simple but powerful. Courts reward diligence, not excuses. Missed hearings, ignored subpoenas, and delayed responses don't just weaken a case, they decide it. Whether you're an individual or a corporation, the rules apply the same way. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns where real consequences meet real decisions.